Thanks for stopping by Podcast 420 and 420lawoffice.com. My name is Stuart Richland, and I've been a lawyer here in Southern California for 22 years, and most recently I've been focusing on medical marijuana. I have an interesting file to discuss with you on this podcast. This is a file where a client of mine came to me because they were considering opening up a medical marijuana dispensary here in Southern California. And although they had blown the deadline to open up a center here in the city of LA under the moratorium, another law firm was making a dispensary package available. This client came to me to review the dispensary package, and I found it atrocious. This is a warning that I'm issuing to would-be caregivers to beware of such an offer. In this particular situation, the client presented me with a bundle of documents that were supposed to be a completed package of a center that was being marketed, a medical marijuana center license that was being marketed by a front man who was essentially working for an attorney. The front man was also sort of acting as an unlicensed attorney, which is a whole nother illegal topic. But just even assuming that the person had the right to make such representations, they were false. My first note is to refer to the DEA federal trafficking standards, which state that any sale is 5 years and $250,000. I pointed this out so the client would not have any confusion that I was recommending or endorsing the caregiving of medical marijuana, just giving information about whether this dispensary appeared to be properly licensed under local and state law. I then reviewed each of the documents in the order presented. There was a tax registration certificate presented, and it was unclear as to whether it was in the name of a corporation or an individual. It listed an individual. Since licenses are generally not transferable, that was the first problem. The second problem is they're not transferable under the moratorium, and that's the second problem. Next, there was a seller's permit that was slightly inconsistent with the tax registration certificate, but not necessarily fatally so. But again, not transferable. There was a medical marijuana dispensary business information form. That was the filing that was done under the moratorium. It stated the name of a company with no specification whether it was incorporated or not. There was also a document that demonstrated that the filing had been made. There was a receipt under the moratorium, but no acceptance for filing, nor was there any statement as to whether the company had gotten any notices or correspondence since their filing from the federal or state governments. There were photocopies of some driver's licenses which were supposed to demonstrate the authenticity of the signed documents, but the documents themselves were not notarized. A photocopy of a driver's license is not a sufficient ID in any event, and whether documents should or should not be notarized, there's definitely a concern in this case as to whether the identities were true as stated. The affidavit of tax responsibility, it appeared to be some kind of document that a predecessor had signed. Apparently this center had already been sold once or twice, and at some point someone along the line signed a piece of paper saying that they agreed to be responsible for any and all taxes that may be due. That may be true as between those two parties, but the tax entity may still come after the buyer under the doctrine of successor liability. So this is not a proper contract under any analysis. Finally, there was supposed to be evidence of property insurance under the interim control ordinance. It looks like some insurance was obtained right before the November 14th filing date, but that didn't include coverage as of the required September 14th date. Thus, it was defective. There was a commercial lease, again with an inconsistent name, and the lease didn't expressly permit medical marijuana. It said medical dispensary. Furthermore, I had another situation where someone presented a lease to me that was actually a lease in a Fijian-type suite, basically a mailbox registration. That was done by a California lawyer and someone who works under him. Amazingly, there were even notaries in that file that had been signed by a California lawyer. There was a hardship application that was supposedly included in this bundle, which was not filed, but which was supposedly intended to fix the insurance date. There was no current information in the file, and the final issue was one of successor liability. Under the doctrine of successor liability, the buyer will be responsible for the seller's taxes, workers' comp, lawsuits, claims, etc., unless tax clearances have been obtained, a business escrow used, and a bulk sale used. So this person was looking for trouble if they would have picked up this center. I'm convinced that there are people out there that have made some quick and bogus registrations that are out to dupe unwary and unknowing potential caregivers out of a lot of money. These people wanted $30,000. I've heard of people asking $100,000 for a so-called license. Buyer beware. These are not proper licenses. Read the ICO carefully, the Interim Control Ordinance carefully, and you'll see that these are not proper licenses. They're not registered properly. They're not transferable. They're not nonprofit. They were not legitimately operating prior to the deadline of the ICO. And on 10 levels, they are bogus bullshit. So please, buyer beware. Do your homework and don't get screwed by a so-called knowledgeable so-called lawyer who just got out of school or who's green in the area of medical cannabis and who's trying to sell you a bill of goods and wind up in Rio de Janeiro with your money. So other than that, though, I hope you're having a great day and take good care until we talk next. Bye-bye.